Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney, and today I'd like to talk to you about claims filed in your Chapter 13 case and what you can do if the claims are wrong. And basically, in any time you file Chapter 13, all creditors are given notice of the filing, and they're given a sent a form in the mail that is called a proof of claim form, and they can also generate these forms electronically or pull them off the internet. And basically, every creditor gets one of these forms, and creditors then file claims. They actually physically file with the clerk of court, either electronically or by mail. They file a claim. So credit card company A, let's say Chase Bank, they file an unsecured claim for $3,421, and Toyota Motor Credit files a secured claim, meaning that there's a vehicle tied to that claim in the amount of $12,500 with an interest rate of 7.6%. So that's how the trustees know how much to pay. And what we do in Chapter 13 as the attorney is I will guesstimate, or really sometimes really rough estimate of what the claims might be, and then I will propose in the Chapter 13 plan that I prepared for my clients a payment schedule. So I'll say that this vehicle payment is going to be, instead of the contract payment of $350 a month, I'm going to pay them at $275 a month, and depending on how old the loan is, I'm able to reduce the interest rate and so forth. And that's really beyond the scope of this video, but the point is that if you ever wondered how creditors get their claims to the court, they file them. Now, what I wanted to talk to you about is what you should do about these claims and what you should do if the claims are incorrect. And one of the things you can do with your attorney's help is you can request a copy of the claims register, and you can actually get copies of the proofs of claim that they file. And as attorneys, we are required to review these claims, but obviously we don't necessarily know if the claim is incorrect. So what I tell my clients to do is let's get a copy of the claims file. I send it to them by email and ask, is there anything wrong here? If there is a problem, what our recourse would be is to file an objection to the proof of claim, or a motion to disallow the claim. I was in court today, and I had a situation where my client owed money to a finance company for a vehicle. We provided in the Chapter 13 that we were going to surrender that vehicle, and nothing happened. The creditor did not contact my client or me to pick the vehicle up. I called the creditor and said, we want to surrender the vehicle. They said, well, we're going to mail you a form. You got to fill it in. And said, I did all that. I called them, nothing. So finally, I said, I need to do something here, because the problem is they filed a secured claim of $15,000, and that claim will be paid by the trustee unless something happens to it. And obviously that's going to create a problem in my Chapter 13, since I'm providing for a surrender of the vehicle. So I filed a motion to disallow the claim. I served the creditor, I served their agent, and a hearing was scheduled for today. Went down to court. Nobody was there. The creditor did not show up. The clerk at the call of the calendar said, anybody here for XYZ Bank? Nobody was there. Then she said to me, present your order. So the order I'm going to present is going to disallow that claim. So $15,000 of secured debt just disappeared from my client's Chapter 13. That's going to make our Chapter 13 a lot more feasible, obviously, because I had not counted on $15,000 of secured debt in my plan. The other thing this is going to do for my client is that normally, if the creditor had been smart about it, they would have taken the vehicle, sold it, and then amended their claim for the unsecured balance, meaning that if they sold the vehicle for $10,000, there's a $5,000 deficiency. That would be an unsecured claim in our Chapter 13. This case happens to be a 100% plan. They would have gotten $5,000. Because they were too lazy to respond, they're going to get nothing, and it's going to save my client $5,000. So that's just a kind of an unusual example of why you should look at claims, but I've seen many, many situations where claims are just wrong. The IRS files a claim based on estimated liability for unfiled returns. Turns out we have returns, and it turns out for the year in question, my client owes no money. We file an objection to the IRS proof of claim or the Georgia Department of Revenue claim. This is done all the time. I've seen situations where somebody's identity got stolen, and Chase Bank or Discover or some other credit card company files a claim based on this stolen identity. If our plan provides for 100% payment to unsecured debt, that's obviously a problem. We would object to it and let the bankruptcy judge determine whether or not the identity theft was legitimate. And again, in that situation, we probably would need to have a police report or some evidence that my client had reported it. But the point is that you need to know, and you need to be proactive as a debtor, what the claims are in your case, and you need to know if the claims are incorrect and you've got evidence of that, you need to get your attorney to file an objection to claim or motion to disallow claim, and a lot of debt can disappear that way. So it's a very, very powerful tool in our arsenal to make claims go away if the creditor does not have proof that they own the debt. If it's a debt buyer, they don't have proof they own the debt, or if there's some other issue with the claim, there's a dispute about interest rates, many times the creditors won't show up or they won't send an attorney, and you win by default. So be proactive about that. Encourage your attorney to request a copy of the proof of claim register. If you're my client, we're going to do it automatically. We want to make sure the claims are legitimate because we're going to pay who we have to pay, but we're not going to pay anybody else a dime more than we absolutely have to. So big picture here, look at the claims file in your Chapter 13 case. Look at it carefully. Look at the actual claims. If there's a problem or dispute, encourage your attorney to object to the claim, and many times, again, it'll be a default because the creditor will not show up, will not send an attorney. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook. Go to my website. It's atlanta-bankruptcy.com and grab a copy of my free Debt Destroyer Survival Kit. Doesn't cost anything. It's delivered by email. I think you'll find that very useful as well. Any questions for me, please reach out to me, 770-393-4985. My name again is Jonathan Ginsberg, and I wish you the best. Thanks a lot. Hi, this is Jonathan, and I hope you found this video helpful. I'd like to invite you to download my free Debt Destroyer Survival Kit right now. I've packed my survival kit with answers to the questions I've heard from clients for over 25 years here in the Atlanta area. Inside the survival kit, you'll find clear, easy to understand answers to critical topics about how to solve debt problems once and for all, including how do I protect my stuff, my house, car, and personal property if I file for bankruptcy? Are there any legitimate alternatives to bankruptcy? Will I ever get credit again, and if so, when? What mistakes must I avoid to get the most benefit out of bankruptcy? You can claim your copy right now by visiting my atlanta-bankruptcy.com website. And you are always welcome to use the email form on my website to ask me anything about debt and personal bankruptcy in Atlanta. www.atlanta-bankruptcy.com. And as always, I wish you the best.